Further hearing in the appeal, Gilham against Ministry of Justice.
My lords, Mr Collins has kindly given me a few moments to deal with the answer to my Lady Arden's question yesterday about the rights that would be conferred upon judges were your ladyships and your lordships reached the conclusion that judges were indeed workers or in Crown employment. So you have a table, I hope, on your bench, and along with identifying the rights that would be conferred on judges, I have also in the right-hand column identified whether those rights derive from or are reflected in EU law anyway. So in other words, in all likelihood, judges would enjoy those rights, whatever the outcome of this case. I should say too that it's been agreed by Mr Collins and Mr Stillitz, subject to two clarifications, one error and two clarifications. Firstly, the right to organise and trade union activities, which is on the second page, second full box. So that's the Trade Union and Labour Relations Consolidation Act, right to organise and so on, including right to strike. In fact, Crown employment is covered, and that's section 273. I just missed
So that should be yes. Where it says no, it should be yes.
Yes, it should be yes, and it's section 273. However, your ladyships and your lordships may think it's important to know that there is a power under the Act at section 286, which permits the Secretary of State, by statutory instrument, to exclude classes of persons, and so prison officers, for example, are excluded from the right to organise collective bargaining and so on.
He hasn't excluded judges so far.
They haven't included judges so far, and who knows, maybe they won't include judges, but it's simply to observe that if the outcome of this case was such that the Secretary of State considered further amendment was required, or that judges should be excluded, there is a ready way to do that.
There were a raft of other points that you mentioned yesterday about paternity leave, maternal pay, adoption, shared parental leave. Where are all they in this table?
They're not there because they only cover employment.
Indeed,
so
that's what I thought.
If the court were to conclude that judges were workers, that wouldn't, subject to EU law, that wouldn't affect their entitlement to paternity, maternity, and so on. Similarly, unfair dismissal, that would only cover employees and so wouldn't be affected by the outcome of any decision by this court. Of course, some of those rights are conferred by EU law, but that's a different question altogether. So the other clarification that it might be helpful to make is at footnote 3, which is on page 3, you'll see that in the national minimum wage regulations, there's no definition of worker, but it covers work. There is, however, a definition of worker in section 36 of the National Minimum Wage Act. We can't find that imported into the regulations. It's the same definition as found in the Employment Rights Act, but I anticipate that it would be read in conformity, or it could be there's a regulation that we just haven't been able to identify. So, in fact, there are very few rights when one removes the rights already conferred by EU law. There are very few rights that would be affected by a positive decision of this court, whistleblowing perhaps being the most important. And, of course, the right to strike, but there is a way around that.
And this table, with those two clarifications, is agreed by everybody.
Yes.
It is agreed, my lady, so far as it goes. There are some submissions when I come to section 191 that I'm going to have to make about whether Crown employment brings with it only worker rights for these purposes or also employment rights.
Or you might therefore be disagreeing with Mr.
Stillitz. Yes, I will be. But I'll
well, we'll look forward to that.
And I beg your pardon. And at page 4, just to identify for the court the limits of the table. In other words, They only cover workers and Crown employees, so that addresses my Lady Alden's question, and they only address rights that are conferred up until yesterday or today. They don't take account of potential future changes like EU proposals for 0 hours contract directive and the proposal to require employers to confer the conferring of Section 1 rights on workers from 2020. Section 1 rights are the rights to terms and conditions of employment.
Thank you. Yes, Mr. Collins.
My ladies, my lords, I plan to make my submissions in the same order as those of Ms Monaghan, that is to deal with the contract issue first, then to look at the question of Crown employment and Section 191, and after that to look at the Article 10 and Article 14 points. The starting point, of course, is that we're all agreed that a district judge is a holder of an office. We agree also that that does not of itself preclude her from also working under a contract. There is no doubt that it is possible to hold office and work under a contract at the same time. We also agree that there is no presumption against a contract arising from the appointment to an office. Office or no office, the court's task is to identify whether the parties entered into a contract. The more difficult question, of course, is how that task should be undertaken. And we would suggest that a helpful starting point is the judgment of Lord Sumption in Preston, which the court has at MS 1021. For those on paper, that's A1 tab 10. The court was taken to this yesterday, so I'll go straight to the passages that we asked the court to take into account, starting with paragraph 8 on page MS 1030. And this is a passage where Lord Sumption comments on Percy. He notes that Lord Nichols regarded office holding as an unsatisfactory criterion, at any rate on its own, for deciding whether a person was employed. The concept is clear enough, but the boundaries are not, except in the case of holders of a small number of offices which have long been recognised as such by the common law, such as constables and beneficed clergymen of the Church of England. And he notes also that offices and employments are not always mutually exclusive categories. Contract of employment is capable of subsisting side by side with many of the characteristics of an office. It followed that the classification of a minister's occupation as an office was no more than one factor in a judgment that depended on all the circumstances. So from that, we derive the proposition that it's right to take the office into account in the assessment of all the circumstances, but it's of course not decisive. We turn on then to the following page, 1031, at paragraph 10, Lord Sumption says this: it's clear from the judgments of the majority in Percy that the question whether a minister of religion serves under a contract of employment can no longer be answered simply by classifying the minister's occupation by type, nor can it be answered by reference to any presumption against the contractual character. And he then identifies what he says are the primary considerations, and we say that the same considerations are applicable here. The primary considerations are the manner in which the minister was engaged and the character of the rules or terms governing his or her service. But as with all exercises in contractual construction, these documents and any other admissible evidence on the parties' intentions fall to be construed against their factual background. In that case, he noted that part of the background was the fundamentally spiritual purpose of the functions of a minister of religion. In the present case, of course, we say part of the background is the constitutional role of the judge. So the starting point for determining whether a contract exists in this case we say, is to look in particular at the manner of engagement, the character of the rules or terms governing service, noting that they can only properly be assessed by reference to the factual background. And to that extent, the Preston approach is, we would suggest, not conceptually different from the authorities which the appellant refers to in her case in the broader employment field, so AutoCleanse and Calvac. And we respectfully agree with the appellant that it's important to take a sensible and robust view of the true nature of the relationship, and that one should not let form undermine substance.
I don't think I said anything different, did I?
No.
We just differed on how we interpreted the documents involved in the Preston case.
Yeah, precisely. And it may be that Lord Hoffman's dissent in Percy can be read similarly. The principles might be said to be straightforward. The working out of how those principles apply to the circumstances of a judge or of a minister of religion are much less straightforward. So what I propose to do, my ladies and my lords, is to start with some broad propositions of principle before I come on to the facts. And I'm going to need to spend a little bit of time going through the facts in detail in order to see how they affect the approach that needs to be taken to the understanding of whether or not there is a contract in this case. Some of the propositions I'm going to start with I suspect will be uncontroversial, so I'll take them as quickly as I can before I move on to their significance for the argument. The first, I'm sure, uncontroversial proposition is that judges must be and must be seen to be independent of the legislative and executive branches of the state. We take that from the Lord Chief Justice's Guide to Judicial Conduct of this year, but it's so obvious that perhaps it goes without saying. That is not only, of course, a constitutional proposition from this jurisdiction, it accords with international norms. Both parties have referred you to United Nations guidance. Included within that are the Bangalore principles, which are in your bundle. Perhaps I don't need to ask the court to turn them up. I'll perhaps, given that these are, I suspect, uncontroversial, I'll give you the page references. The Bangalore principles start at MS 3340, and I start with the proposition at 3387 that a judge shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of government, but must also appear to a reasonable observer to be free therefrom. And in the commentary to the principles, this is the UN's commentary, paragraph 23 at 3379, reference to assuring both the reality and the appearance of independence. Paragraph 37 at page 3387, the test for independence should include perception. 1.4 at 3390, in performing judicial duties, a judge shall be independent of judicial colleagues in respect of decisions which the judge is obliged to make independently. Paragraph 25 at page 3380, judges owe no loyalty to ministers. And paragraph 40 at page 3390, in the performance of his or her functions, a judge is no one's employee. And we say all of that is consistent with the Court of Appeal's observation in this case, that it's in principle desirable to have as much visible distance as possible between the judiciary and the executive. That's paragraph 69 of the Court of Appeal's judgment below, in this case at page 203. And I'll come back to what that means in practice for this case when I address you on the facts. Before I get there, I'd mention one other feature of the constitutional backdrop which we say is important to have in mind when undertaking your objective assessment of the relationship, and that's the protections provided to judges. And those protections about which you heard yesterday, in particular in relation to security of tenure and of pay, are set out in statute, and they have as their origin the objective, again, of maintaining the independence of the judiciary. We've included in the authorities bundle an article from Sir Henry Brooke, page 3306, which traces the history and development of the independence of the judiciary. I don't propose, my ladies and my lords, to go through 1,000 years of legal history in the course of my time this morning.
Sorry, what was the page number for Sir Henry Brooks?
3306.
Thank you very much.
And there's a section which we'd suggest may be particularly helpful, starting at page 3312, which looks at the way in which security of tenure and security of salary are means by which the independence of the judiciary has been assured.
Well, cannot all of this coexist with a judge operating under a contract? It doesn't require that you remove the judge from a contractual relationship in order to guarantee all of these vital indicia of independence, does it?
What it does in the first instance is to inform the basis upon which the parties dealt with one another and our understanding of that when the court comes to consider what their intentions were. But there are difficulties, and it'll take me a little time to explain, but that's part of the task, of course, that I have this morning. There are difficulties, we say, that arise from a contractual relationship in relation to judicial independence. There's no one-sentence answer to my Lord's question.
Take several paragraphs.
We'll wait.
Just in the context of the history, can I also refer at this stage to the three older cases to which you were referred yesterday? So that's Terrell and Knight and Sheikh. And the Court of Appeal dealt with those in this way, which we say is a sensible way to approach it. They said that those cases are of some value as reflecting a general understanding that the rights and obligations of judicial office holders arose from the office rather than from contract. Paragraph 44 of the judgment below, page 191. And just by way of very brief reminder, Terrell, which is 2999, was the case of the puisne judge of the Supreme Court of Malaya, who was removed from office, and there was a question whether there was a contract in his case, and Lord Goddard held that a judge holds office by royal appointment and not by contract. Knight, Mr. Justice Slynn, as he then was in the EAT, looked at the position of justices of the peace, held he's not employed under a contract of service or apprenticeship, nor does he make with the Crown a contract to execute personally any work or labour. And at it's page 200 of the report. I'm sorry, I haven't noted the MS number. But the comment is that if there is here service, it seems to us it's clearly not for the purposes of a minister of the Crown. JPs render their services to the Crown itself and not to a minister. And then Sheikh at page 2810, the finding of the EAT that Social Security Appeal Tribunal members don't have contracts of service. Of course we don't say that those cases of themselves lead you to the conclusion that judges looked at today or at any other point cannot have contracts. We put it no higher than the Court of Appeal put it. which is that they are of value in reflecting a general understanding. It forms part of the background against which you must assess the relationship between the parties. We draw the analogy with Preston. In which Lord Sumption looked at the background and the general understanding of the way in which the church arranged its affairs. It's page 1036, if I can ask the court to look at that. For those on paper, tab 10 in bundle 1. There's a section in paragraph 26, and I'm going to need to come back to some other parts of this paragraph. So, in fact, I might read all of it out now to save time and coming back.
Why don't you let us
later.
read it?
I will do, my lady.
On 26.
Yes, please.
I'm sorry, did you have an MS number?
1036.
Thank you.
I mean, in the church, you've got a whole range of different types of organisations. I mean, in a sense, from your point of view, the position of the judiciary is rather clearer because the basic position of the judiciary in the Constitution is not in doubt and is very well established. And here you've got cases going back to 1950, which take a pretty clear view. And aren't you entitled to say, well, Parliament can be assumed to have at least legislated against that background?
My Lord, we do put it that way, and we also say that it's relevant to conclude that if it would have been a novel proposition to suggest that judges work pursuant to contracts with the minister, that's a relevant factor to take into account when undertaking the assessment of what was in the parties' minds when they entered into these arrangements.
Was one of the things about Preston, which was rather different from Percy, was the nature of the documentation from which any contractual obligations could be deduced. One didn't have a clear set of documents as there was in Percy, and as arguably, I put it no higher than that, there is in this case.
Yes.
It all had to be worked out by a detailed consideration of the foundational documents of the Methodist Church. I remember it vividly. A very fine exercise was conducted by Miss Rose, Queen's Counsel, in taking us through those documents, which had to be done if there was going to be any sort of contract construed. Not, mind you, she was arguing that there wasn't, of course, but so the factual background in Preston was very different from that in both Percy and, as I say, arguably in this case.
My lady, yes, that's undoubtedly right. And it's why I said at the outset I'm going to have to spend a little bit of time going through the documents and looking at what the terms mean. These general propositions form the backdrop to the way in which we say that you should assess the written documentation, because you have a submission from the appellant effectively saying, well, we can see an offer here, we can see acceptance, we can see terms, they're plainly intended to be legally binding, and that's sufficient. But we say you can't look at the documentation and you can't understand what it means objectively unless you understand the nature and the circumstances of that offer and the work and the salary and so on. And so where Lord Sumption talks in Preston about looking at the terms of engagement, the terms in their factual content, in their factual context, that's what we ask you to do here. Can I just say this in response to, it's not a point that was pressed orally, but certainly in writing, the appellant suggests that the approach taken by the Court of Appeal and the tribunals below was what they describe as a subtraction approach. That is to look at what's attributable to office and then see what's left. And we say that's not the way that it's been done. We agree it's not the way that it should be done. But of course, in almost every case, there are going to be factors which have the ability to point in both directions. And the proper approach must always be to consider all of them against the factual background. So that's the broad introduction. Can I then turn to the detail, starting with appointment, engagement. The office of District Judge, as you know, is a creation of the County Courts Act 1984. We have...
Well, it's a much longer history than that.
Certainly is.
We'll go back to the creation of the county courts in 18, whenever it was.
My lady, I'm not going to try to do that. I'm going to look at the position of this judge in the context of this appeal. And at page 1359, bundle 2, tab 27, we see section 6 of the County Courts Act as it was at the time of this judge's appointment. Section 6, subsection 1, there shall be a district judge for each district who shall be appointed by the Lord Chancellor and paid such salary as the Lord Chancellor may, with the concurrence of the Treasury, direct. That position was changed with the Constitutional Reform Act 2005, and the up-to-date version is on page 1361, tab 28. Her Majesty may, on the recommendation of the Lord Chancellor, appoint district judges. The recommendations themselves, of course, arise from selections undertaken by the Judicial Appointments Commission. And that's a change which underlines the need for the appointments process to be sufficiently free from the influence of the executive, of course. Of course, that's not to say that it was not free from that influence before the 2005 Act. Before the 2005 Act, selection was by the Lord Chancellor in circumstances where the holder of that office had to undertake separate roles in relation to the executive and the judiciary. But the important point is that the Lord Chancellor did not, we would say, and does not select individuals to work for him or her. The individuals are selected to perform their statutory role irrespective of the position of the Lord Chancellor. And the court's seen that since 2005, the appointments themselves are made by Her Majesty. And we say that's why there's no reference to contract, as the Court of Appeal noted, in the correspondence leading to appointment or in the instrument of appointment. Of course, language isn't determinative, but it's an indication, we suggest, that neither party thought they were entering into a contract. The other point that we make in this regard is that a contract is an agreement between parties, which is why Lord Justice Maurice Kay in the Court of Appeal and O'Brien asked the rhetorical question which has featured on a number of occasions in the passage of this case through the courts: which other party? This judge happens to have been appointed just before the 2005 Act, such that her appointment was by the Lord Chancellor. and I'll come on when we look at the terms to try to illustrate the difficulties with identifying him as the other party to the contract. This claim, of course, was brought against the Ministry of Justice. It was only in the course of oral argument before the Court of Appeal that it was suggested that the contract might in fact be with the Lord Chancellor. At the very least, that demonstrates that this is not a straightforward case of offer and acceptance. The appellant's difficulty in identifying the other party to the contract is one factor which may suggest that there's no coherent answer to Lord Justice Maurice Kay's question. And even in submissions before this court, we detect a hesitation in identifying who is the other party to the purported contract. And we say the reason for that is that this appointment process simply isn't susceptible to analysis as a contractual offer and acceptance between two parties. And we suggest that the realistic and robust view must be this: if we are going to have judges, somebody has to be given the task of appointing them. That is a task which is allocated by Parliament. The process of appointment necessarily requires that the person charged with the responsibility of making that appointment makes an offer to the individual. And the appointment, of course, can't take effect without the individual accepting that offer. And in this case, that offer was made by the Lord Chancellor to the appellant against a statutory and constitutional background which we suggest objectively makes it abundantly clear that he wasn't offering her a contract to work for him or for anyone else. Turn on to the terms, and I start with salary. Section 6.5 of the 1984 Act deals with this. It's at page 1362. A district judge is to be paid such salary as may be determined by the Lord Chancellor with the concurrence of the Treasury. And 6.6, a salary payable under this section may be increased but not reduced by a determination or further determination under this section. A salary can't be negotiated between the parties. The judge can't negotiate. There are furthermore restrictions on what the Lord Chancellor can do. He or she may not reduce the amount of salary. He or she requires Treasury approval. It's a result of those statutory provisions that no salary reduction would be permissible in a case of sickness absence. The court may have seen from the statement of facts and issues this appellant was off sick for a little over 6 years between January 2013 and March of this year. She was paid in full throughout. For your note, it's paragraph 5 of the amended statement of facts and issues at MS 75. That was the correct approach because there is no basis for her salary to be reduced or withheld in light of Section 6. You were taken yesterday to provisions of the memorandum on district judges. It's MS 736, paragraph 38, which does make provision for sick pay. That wasn't applied in this case, and with respect we say, nor could it have been, for the reasons that I've identified. That is an illustration, we say, of the fact that the Lord Chancellor cannot reach agreement with an individual judge about pay. It is not possible for the parties to reach agreement about when sick pay will be paid, how much, and for how long.
Is that a universal practice?
I'm not aware of it not having been followed, my lady.
So why does the memorandum say what it says?
Why it says that, I don't know. It shouldn't say that. The my instructions from the respondent are that it is recognised. It's recognised that it's not possible. And in fact, if I can take you to the original provision, that's at page 736. That's from the 2005 memorandum. That's the provision that you were taken to. It's paragraph 38. Where there are references to reduction down to half pay and maximum amounts. That's the paragraph we say is wrong. In fact, grateful to Mr. Moretto, who pointed out that problem was rectified by 2009, as if one turns to MS 813, paragraph 42, no adjustment in a district judge's salary is made during any absence by reason of sickness. Paragraph 38 in 2005, we suggest is an anomaly. And that's because the entitlement to salary arises not from the performance of the work, but from the holding of the office. We say that's important because it's characteristic of an office and it's not characteristic of a contract to provide work. The salary that is paid out of money provided by Parliament. That's section 132, page 1365. And pensions are provided by statute and paid out of the consolidated fund. And again, there are good constitutional reasons for that. The way that Sir Henry Brooke puts it in the article that I referred you to, it's at page MS 3314, immunity from removal from office wouldn't count for very much if the executive branch of government was at liberty to reduce a judge's pay if it didn't like his or her judgments. The reason for that statutory protection is perhaps obvious.
Well, plainly, there are constraints on what one might describe as the contractual capacity of whoever is said to be in contract with the judge. But the question is, the ultimate question, I suppose, is whether those constraints extinguish the possibility of a contract or merely impose fetters on the capacity of the contracting party.
Suggest, my lord, it's not quite as straightforward as whether they extinguish the right. It's what they tell us about the character of the arrangements made between
yes,
the
quite,
Lord
but
Chancellor and the judge
that
in this
rather
case.
begs the question, doesn't it? The issue is whether or not whoever is said to be in contract, and of course, Ms. Monaghan says it's not a prerequisite that you identify the other contracting party. Leave that question aside for the moment. I mean, if you're examining the question whether there is the opportunity for a contract, because there are constraints on what the contracting party on the Ministry of Justice, Lord Chancellor side, doesn't mean to say that that there is no possibility of a contract being made, does it?
I don't suggest the Lord Chancellor has no capacity to enter into contracts. I rely on these provisions because we say when you look at all of them taken together, they demonstrate that that wasn't what the parties intended in this case. And that's because of the way in which salary is paid, taken against the history and the constitutional backdrop to it. But I don't suggest that the Lord Chancellor is in a position where he has no capacity to contract at all, we say that when we look at all of the circumstances, it becomes clear that that is not what he intended to do and not what he intends to do in any case of the appointment of a judge to judicial office.
Yes.
The assignment of the judge to a district registry is a statutory role which falls to the Lord Chief Justice. That is consistent with the fact that it's the Lord Chief Justice, not the Lord Chancellor, who is head of the judiciary. And as for the work performed by a district judge, her functions arise under a range of statutory provisions, including rules of procedure made under statutory authority. I don't propose to go through a list of those because I suspect it's uncontroversial. If it assists in our skeleton argument before the Court of Appeal, we did provide a list. It's in the bundle if it's of assistance. It's MS 433, paragraph 48. But in terms of duties, the appellant herself, in her claim form before the Employment Tribunal, refers to her duties having been imposed by her position of public office. And the Lord Chancellor has no power to change those duties. They don't arise from any agreement between parties. They arise from the judicial office which the appellant holds. You were taken yesterday to the statutory provision which means that a judge can't continue in private practice in accordance with Section 75 of the Courts and Legal Services Act 1990. Again, that's not something that the judge and the Lord Chancellor could reach agreement about. It's a statutory requirement. And when one comes to the question of deployment and allocation of work, that too is a responsibility of the Lord Chief Justice in accordance with Section 7 of the 2005 Act. In practice, of course, the Lord Chief Justice does not himself allocate work to each individual judge. The task is delegated to local judiciary. They themselves may delegate some of the tasks to court staff. But it's clear that the Lord Chancellor has no role in allocating work, whether under contract or statute. And again, there are good constitutional reasons for that, we say. Amongst the UN Basic Principles on the Independence of the Judiciary, upon which the appellant relies, MS 1341, is the proposition that the assignment of cases to judges within the court to which they belong is an internal matter of judicial administration. And within the Bangalore Principles at page 3381, paragraph 26C, requirements of institutional independence, that is, independence with respect to matters of administration that relate directly to the exercise of the judicial function. An external force must not be in a position to interfere in matters that are directly and immediately relevant to the adjudicative function. For example, assignment of judges, sittings of the court, and court lists. So it is important, we would suggest, that ministers can't be involved in directing or reaching agreement about matters that are matters for judges, including assignment of judges, sittings of the court, and so on. There's one domestic authority which deals with the point. It's a case called Engel, page 2053, bundle 4, tab 49. Decision of Mr. Justice Mitting, sitting in the EAT. Can I ask the court to read paragraph 15, please, on page 2053?
This is one of these areas where there's a long-standing gap between theory and practice. It's always been in the interests of the administration to say that listing is a judicial function, but in reality, of course, listing is an administrative function that is done by officials under some judicial guidance, but only some.
It may only be under some judicial guidance, but it is a matter of judicial delegation.
Well, yes, that's what I say. There's a big gap between the theory and the reality.
Well,
if you're overlisted as a judge in a particular court, who would you go first to complain? Well, you'd go firstly to the court management. You might later take it up to the your leadership judge. And you might even later take it further still. But it's a matter of absolute practice. We get given a list, we do our list.
I don't dissent for a second from that. All I'd say is that that's not in contradiction of the theory, because the court staff are acting not under a delegation from the minister, they're acting under a delegation from the judiciary. And it's not...
the trouble about this, we're sort of considering this pre-2005 Act, but the whole point about the 2005 Act settlement is that you have joint responsibility of the Lord Chancellor and the Chief Justice, which is then exercised through a joint board, management board, which has a duty of running the courts, but obviously reporting to judges. So it's a joint exercise. Now, where that takes us as far as this is concerned, I don't know. But
my Lord, it's a joint exercise in this respect, that the Lord Chancellor's function is to provide the facilities and administration which enable the courts to run. But it's the Lord Chief Justice's function, and it's the judiciary's own function to administer justice, if I can put it that way.
I think your point is that there's a clear demarcation between the responsibility of the Lord Chancellor and the responsibility of the judiciary. It may well be that, as my lady says, in fact, it unquestionably is the case that it's the administrative staff who are primarily responsible for listing. But your point is that they do so in the capacity as servants of the judiciary rather than as servants of the Lord Chancellor.
My Lord, yes. The appellant places reliance on the fact that there are all sorts of other matters set out in the memorandum. And one of the things that the Court of Appeal below indicated was that they took it to be of some significance that many of the matters in the memorandum are expressed as expectations or understandings, matters along those lines, rather than in the language of contract. And one of the examples of that is number of sitting days, which is expressed to be on the basis that the Lord Chancellor and the Lord Chief Justice consider it essential for district judges to devote 215 days each year to judicial business. I think you were told yesterday that's the standard public sector year. I'm told the standard public sector year is in fact 220 days. I'm not sure anything turns on that.
Extra 5 days then.
Slightly shorter in Northern Ireland, I believe. I think it's
Oh, well, that's
218
because
in
of the-
Northern Ireland. But
Because of the pressure being Lord Chief Justice in Northern Ireland.
It's because we have to march in 2 days.
we say it's only a small point, but the way in which these terms are expressed in the memorandum points away from contract, points away from these being arrangements put in place to permit the operation of the office and arising from the nature of the office rather than from agreement. The fact that these various responsibilities are allocated differently, of course, is answered by the appellant with the proposition that this is a case of fragmentation, to use the expression of Lord Nichols in Percy. Perhaps we could just look at what he said. It's page 986 is the MS number, tab 9 in bundle 1 for those on paper. And it's paragraph 28. Well, it starts at paragraph 27, which talks about the difficulties of a nationwide church whose complex affairs are conducted through a multiplicity of boards and committees. And then at 28, Lord Nichols says that the different bodies are in a broad but real sense all part of the church in question, but the church may not be an entity capable of making a contract of suing or being sued. This is so with the Church of England, equally so with the Diocese of the Anglican Church, also true of the Church of Scotland. Then the fragmentation of functions within such an umbrella organisation may make it difficult to pin the role of employer on any particular board or committee, but this internal fragmentation ought not to stand in the way of otherwise well-founded claims. We say that's difficult to read across into the present circumstances. We are not in a situation, as I think I observed earlier, that the Lord Chancellor or the Lord Chief Justice are not themselves capable of entering into a contract, or indeed the Secretary of State. They are each capable. What we say is that it is not appropriate for a member of the executive to enter into a contract with a judge, for the judge to provide services for the benefit of the executive in circumstances such as this. Because if that were the case, a judge performing their functions pursuant to a contract with the Lord Chancellor would, in a case in which the Lord Chancellor was one of the parties, have to wrestle with a difficulty in relation to apparent bias.
Well, of course, we've got a bit of that problem, haven't we?
Well,
Adjudicating on this dispute. We happen all to be judges.
my lady, yes. And
who else can do the job?
Well, my lady, our submission is that this court can do the job precisely because you are public office holders.
We're office holders, yes.
And you are not performing your function by virtue of a contract with my client, which is the appellant's case.
Well, are you suggesting that if we were to find that there was a contractual relationship, that there would be an issue of apparent bias?
Yes. I cannot. I
As my lady says, who else can do the job?
Well, that's the difficulty that one ends up in. The rule identified by the House of Lords in Pinochet is that a judge is automatically disqualified where they're involved in promoting the same causes in the same organisation as a party to the suit. And we say that if the appellant were right, that members of this court are performing their functions as parties to a contract to one of the parties in this case.
I'm not sure that Ms Monaghan has argued that Supreme Court judges hold their office under a contract with the Lord Chancellor.
Well, my lady, she was asked a question yesterday about Supreme Court judges, and I noted she was careful not to make a submission one way or the other about the position of Supreme Court judges. But Supreme Court judges hold their position pursuant to statutory arrangements. They undertake public functions, but the work that they do must be subject to rules and practices and processes. And it's an unavoidable consequence of the appellant's case, we would submit, that the assertion that a district judge holds a contract leads to the consequence that a justice of the Supreme Court is in essentially the same position.
Well, we've all been judges in other positions. I'm in Court of Appeal, in my case, High Court. And I've been slightly surprised that my role has changed in terms of whether there was a contract or not over that period. I mean, I've always assumed I was holding an office, but it certainly never occurred to me that I was in a contractual relationship with anyone.
My lord, yes, and we respectfully suggest that that's likely to have been the case for any judge who's been appointed to office. Certainly we rely on that as a relevant factor in looking at what the party's intentions were in this case in 2005. But we say the only sensible answer to the difficulty which would arise from the contractual analysis in this case is that judges don't hold contracts. All of the aspects of the role of a judge in terms of appointment and terms and termination relate to the office. The minute one starts trying to identify ways in which they form terms of a contract, one does get into difficulties with judicial independence, and one gets into difficulties in trying to really ignore parts of the factual background, which, if one is to make an objective assessment of the intentions of the parties, are essential.
Assuming that I have just held an office rather than being on a contract, how do you say I would have been able to enforce it if I'd needed to do so, or you would have been able to enforce it against me?
Well, my lord, first of all, it depends what aspect of the office it is that needs to be enforced.
Well, any of the terms set out in the memorandum.
Well, first of all, if my lord were to be removed from office, there would be a straightforward public law claim in those circumstances. If there were a failure to pay salary, there would be either a claim for judicial review of the decision not to pay the salary, or there would be a claim for breach of statutory duty.
But if I don't turn up for work, can someone get an injunction to make me turn up for work?
Bound to say, I'm not sure whether the question of specific performance in the context of judicial office has been considered. Certainly it's right to say that a judge, there's no reason of principle why a judge ought not to be able to obtain an injunction to enforce a judge's proper treatment. So, for example...
I mean, you say I can always go for judicial review and I get an injunction, but I think of the other way around. No one can get judicial review against me in my personal capacity.
My lord, I'm sure that's right.
So I'm just wondering what the Lord Chancellor or the Minister, or maybe Hale, whoever it is, would do.
I'm giving it very careful thought.
Yeah. But I mean, my trouble is that it seems to be accepted that, as Lord Hoffman said in Percy, you can have an office with terms and conditions, and that's a perfectly acceptable, understood form of relationship. So, fine. Now, we're going through all these terms and asking ourselves whether they imply a contract. But as far as I can see, it seems to be common ground that they're perfectly consistent with there being an office and not a contract. But I'm just trying to test that by seeing how actually you enforce from both sides the office, the terms of the office.
My Lord, yes. I have to say, we've given thought to how a judge might enforce the terms if they were not put into effect. I've not before this morning given thought to how it works the other way round. Can I ask for some time to have a think about that?
Well,
I'll still be on my feet.
What if
this
my lord
afternoon.
went, after he retired, went back to the bar and appeared before us? How would the Lord Chancellor set about restraining him from doing that?
The starting point is we say there's no contractual term that a judge is not entitled to return to practice after they relinquish their office. The convention, I'll call it that judges do not return to practice, is seen as something enormously important for the benefit both of the judiciary and for the legal professions and the public. But I don't go so far as to suggest it's impossible or there is a means of enforcing it.
So it'll be very interesting for, I'm sure, the judiciary generally, that there's no legally enforceable means by which judges who retire can be restrained from going back to practice.
My Lord, it's not been tested, and I don't have instructions as to a specific position which my client would take in those circumstances.
But certainly at the moment you don't suggest that there is some ready legally enforceable means of restraining a judge who purports to do that.
No.
Right.
There was some discussion yesterday, I recall, about whether there, even if there were a contractual term, it would be in restraint of trade or anything along those lines. But our submission is we don't get there because.
Well, that's a separate question, isn't it?
Yeah.
The first question is whether firstly, there is a legal obligation as opposed to an understanding.
Yes.
And secondly, if there is a legal obligation as opposed to an understanding or expectation or general hope.
Yes.
How it could be enforced.
Yes. What is impossible on our analysis is to seek to enforce it by way of a claim for breach of contract. I'm still working through the terms, I'm afraid, and there are some more that I need to address the court on. Welfare, training and guidance. Those are matters for which the Lord Chief Justice has responsibility, pursuant to Section 7 of the 2005 Act. So if a judge is not provided with appropriate arrangements for welfare, training or guidance, complaint, it follows, must be made to the Lord Chief Justice. Can I ask the court to look at Percival Price, which considers at least some of this, albeit in a slightly different context. It's MS 966, tab 8 in bundle 1 for those on paper. Passage to which you've been referred more than once is on page 970 in paragraph 26. And it's the passage that starts roughly in the middle of the section in the right-hand column. All judges at whatever level share certain common characteristics. I won't read it all out again because I know the court was taken to it a couple of times yesterday.
I think that's the bit I quoted in Percy.
Yes, you did. We didn't get to the end of the paragraph, and I want to take us to the end of the paragraph. The last 4 lines say this: their office accordingly partakes of some of the characteristics of employment as servants of the state, even though as office holders they do not come within the definition of employment in domestic law. So it is possible, and the Court of Appeal thought that was what was going on here, to have a set of arrangements which partake of some of the characteristics of employment, which might be said to look in certain respects like employment, but which do not come within the definition of employment in domestic law. And just to be clear, this is a case about employment as a worker, not employment as an employee. It's an equal pay case. Mention of statutory office, and I'm going to deal with that in a moment. But the important point that we derive from this is that it is, in the context of an office, perfectly possible, and in many cases rather likely, that the arrangements made in the context of an office will reflect arrangements which are commonly made in the context of work and context of employment. So all this paragraph, we would suggest, says is that there are those sorts of practical similarities between the relationship of employment and the circumstances of judicial office. That may be true for all sorts of offices. Lord Sumption noted that in Preston. One can think of constables as well. It's axiomatic, or has always thought to be, at least until now, that the constable doesn't serve by reference to a contract of employment. But the arrangements look rather similar to one. And of course, the Court of Appeal in Northern Ireland, in Percival Price, does not appear to have been asked to consider the factual circumstances in the systematic way in which the courts in this case have been asked to consider them. Just finally, before I turn on to termination, there was mention yesterday of tax and national insurance. That unfortunately doesn't assist us either way, because tax and national insurance is levied on income from employment or office. So the fact that we have Schedule E income tax and national insurance under Section 2 of the Social Security Contributions and Benefits Act 1992 doesn't assist us. Termination then. So security of tenure applies, as the court knows, Section 11 of the County Courts Act. The appellant is removable only with the consent of the Lord Chief Justice. And we say that is a compelling factor which points away from the existence of a contract if one of the parties has no ability to terminate it. And the Court of Appeal relied on the case of Lincolnshire County Council and Hopper. Don't ask the court to turn it up. It's page 2179 for your note. Not only is it necessary to secure third-party agreement before termination is possible, but removal on disciplinary grounds can only be achieved through the application of the statutory process. And you've been referred already to the Judicial Discipline Prescribed Procedures Regulations 2014 and the 2014 rules. So even the Lord Chancellor and the Lord Chief Justice together can only remove from office when those procedures have been gone through. There's no agreement between the parties as to what approach will be taken. Neither party has any option because the requirements are statutory requirements. The appellant mentioned a couple of times yesterday the fact that in some of the clergy cases there's not even an ability to resign their lifetime appointments. And we suggest that doesn't really assist with this case, because your task, I think the appellant acknowledges in her case, is not comparing this case with the clergy cases. The clergy cases are useful to us because they identify principles which we can apply to these facts. But it's impossible to derive from any of those cases a proposition that it's a requirement for there to be a pure office situation, that the office be for life. There's nothing about an ability to resign which points towards the necessity to find a contract. So that doesn't assist either, we would suggest. So to try and pull some of those threads together, as Lord Hoffman put it in, it's a dissent in Percy, but this part of it I hope is uncontroversial. There's plainly an intention to create legal relations. Perhaps I'll ask your ladyship, your lordship, to look at it. The page is 993, please. Within tab 9, bundle 1. By letter E, there was plainly an intention to create legal relations, but those legal relations were not a contract of employment. Now, Lord Hoffman's finding that on the facts of this case it wasn't a contract of employment is a dissent, but the approach, we say, is useful. They were an appointment to a well-recognised office, imposing legal duties and conferring legal rights. The nature of an office inevitably means that the procedures for appointment will closely resemble those attending the engagement of an employee. No doubt similar documentation could be found concerning the appointment of, among many others, judges, rent officers and superintendent registrars of births, deaths and marriages, but that does not mean that their appointment to these offices created contractual relations. One has to ask in the circumstances of this case, what was the intention? And the intention, of course, is to be determined objectively by reference to all the circumstances. And we say that's the way the question was analysed by each of the judges below. And we say they reached the correct conclusion, namely that there is no contract which can be derived from these facts.
What's the nature of the legal relations that are created if they're not contract?
The legal relationship between the Lord Chancellor and the judge is limited to the Lord Chancellor's role in appointing in the first place, and then the Lord Chancellor then has a responsibility to provide facilities for the courts in general. That's not a direct relationship with the judge. The Lord Chancellor could have a further relationship should termination prove necessary. But in fact, there isn't a direct relationship that subsists in the way that a contract subsists between parties. What subsists is the legal effect of the appointment. And that is a set of statutory duties rather than a relationship with one or more individuals.
The legal relations between the Lord Chancellor and the appointed judge are, well, heavily circumscribed, but at its lowest.
At its lowest, they're heavily circumscribed, but we put it a little higher than that, I think it's fair to say. We go further and say, in fact, there is no ongoing legal relationship, save insofar as circumstances may arise where there are interactions between the two.
So you create a sort of ephemeral legal relations, but I don't require an answer to that.
Well, let me answer that. It's not that there's an ephemeral legal relation between the Lord Chancellor and the judge. The judge finds herself in a set of legal circumstances prescribed by statute as a result of the actions of the Lord Chancellor in appointing her. Had this been in 2006, it would have been as a result of the Lord Chancellor having recommended her.
I appreciate all of that, but I'm just wondering what Lord Hoffman meant when he said there's plainly an intention to create legal relations. I just wonder what the scope of the legal relations between the appointee and the Lord Chancellor was, seems to me to be a heavily, well, if not circumscribed, certainly vanishingly small.
Very limited, my lord, I agree. We would also say that an appeal to a purposive construction can't change the analysis that we have made submissions on. Of course, in general terms, we agree that it is in the public interest that individuals should not feel inhibited from disclosing wrongdoing. And of course, it's in the public interest that judges speak freely and appropriately in accordance with their position. But that public interest, we say, can't mean that the court is constrained to find a contract in circumstances where, objectively speaking, there is none. And we say that's thrown into relief perhaps in the present circumstances, firstly by reference to, I'll develop this a little later in my submissions, the protections available to judges who do wish to make disclosures in the public interest. And secondly, in light of the good reasons that I've outlined why we say the parties have chosen to structure their relationships as they have done, that is, other than by means of a contract. And what we would say, in particular in relation to this contract issue, is that nothing in O'Brien undermines that approach. The Court of Justice, of course, was not considering the question of a contract at all. The Court of Justice held that the principle of judicial independence is not undermined by extending to judges the scope of protection against discrimination in EU law. But of course, among the member states, there will be a range of constitutional arrangements in place to allow the judiciary to perform their functions. So in the EU context, there's nothing surprising about the application of the broader concept of employment relationship to judges. The requirements of our domestic law are different, and you are asked to consider further and different matters than were before the Court of Justice in O'Brien. So we respectfully submit that there's no difficulty in finding there is no contract in this case.
Were you going to say anything about the desirability of fragmentation in this area?
What we would say, my lady, is this. It's a different sort of fragmentation to begin with.
Yes, I put in quotes.
There are different circumstances in play with different fields of protection, and I'm conscious that I will have to come on to explain why it is sensible to treat a judge as outside the scope of the whistleblowing provisions of the Employment Rights Act, whereas, on the other hand, a judge is included in the discrimination provisions of the Equality Act. And that's particularly going to be a matter of significance, I suspect, when I get onto the human rights part of the claim. So, my lady, I hate to dodge a question, but it's quite a long answer to the question. And if it's convenient, I wonder if I can come back to it when I get to the human rights part of the argument. If my ladies and my lords are with me in relation to the question of contract, then of course you are invited to conclude that as an alternative, this appellant falls within section 191 of the Employment Rights Act and that she is in Crown employment. Can I ask the court to turn the Act up That's 864, please. Subsection 3 to section 191 is not the easiest statutory provision to read. What we suggest the wording of the subsection means is as follows. One starts with the proposition that in this Act, Crown employment means, and what follows is a statutory explanation of what Crown employment means. It means employment under or for the purposes of two different possibilities. First possibility, a government department. Second possibility, any officer or body exercising on behalf of the Crown functions conferred by a statutory provision. In either of those cases, it is employment under or for the purposes of one of those two options. At first glance, this subsection has certainly been read, and I think it may be a way that I've read it at least on one occasion, as though an officer or body exercising on behalf of the Crown functions conferred by a statutory provision is somebody in Crown employment. But that can't be what it means. It's not what it means, because it follows on from the starting point, Crown employment means. And employment can't mean an officer, would have to be work as an officer.
So it really should be Crown employment means employment under or for the purpose of government department or of any officer or body exercising.
My Lord, yes. The draftsman might have made life easier for us had there been a colon after of in the first line, and then A, a government department, or B, any officer or body exercising on behalf of the Crown functions conferred by a statutory provision.
So employment governs any officer or body exercising on behalf of the Crown functions and so on.
The officer is not, by this provision, in Crown employment. It's those in employment under for the purposes of the officer who are in Crown employment. Because otherwise it would say Crown employment means any officer. And that would not make sense.
No, it doesn't really scan very well.
No. So we perceive the two options being there because there are some civil servants who work directly for government departments and some who work separately for example, non-departmental public bodies.
I suppose you might say Her Majesty's Courts and Tribunals Service.
That may well be right. Well, I've no doubt that they're in Crown employment. Whether they're directly employed by the department or employed by the Courts Tribunal Service,
It's quite interesting.
I don't know.
It's quite interesting in the light of our earlier discussion.
Yes. They are caught by whichever of the two options.
Definitely one or the other, but
Yes,
interesting
indeed.
which.
Now, the question was asked yesterday where it says Crown employment means employment under or for the purposes of. What does employment mean in those circumstances? And we are given limited assistance by the draftsman in understanding that.
Well, in effect, your argument is that section 1913 contributes absolutely nothing to the debate. Is that right?
Well, the appellant has to bring herself within that
Yeah.
subsection in order for this argument to go anywhere.
Yeah.
In order to do so, well, I'll deal with under or for the purposes of in a moment. But first of all, she needs to establish employment. Learned friend Ms. Monaghan initially suggested, I think, the question, what does employment mean, is answered by reference to subsection 4. That's where 4A indicates that references to an employee or worker shall be construed as references to a person in Crown employment. We suggest that's not the right way to look at it. All subsection 4 does, and I'll use 4A as an example for it, is to say that when one finds in the Employment Rights Act, for example in section 13 or section 98 or whatever it may be, a reference to a worker or a reference to an employee, one treats that reference as a reference to a person in Crown employment. That's what 4A provides. Doesn't tell us anything about whether an individual is in Crown employment or not.
But the point was that employment in subsection 3 cannot mean employment under a contract of employment, because otherwise there will be no need for the provision.
Absolutely.
I think that's the point that's being made. It has to be generally something like service, which in fact was the expression used in other versions.
It's the expression used in the Northern Ireland
the Northern Ireland
we looked at in
yes.
Percival Price. Service, of course, has connotations of employee rather than worker, historically, but I don't want to take that point further than I should. But it is going to be necessary, I suspect, for this court to reach some conclusions about, in fact, what employment means, acknowledging that it can't mean employment under a contract of employment, otherwise section 191 would be meaningless, it would be circular. And in this context, can I deal with Mr. Stilitz's submission that subsection 1 draws a distinction between employees and workers, such that one can have somebody who is in a relationship according to that of, analogous to that of a worker relationship who would be treated as a worker, and an employment relationship who would be treated as an employee. And we recognise, of course, the attractiveness of that submission for Mr. Stilitz, because it gets around the difficulty which we identify, that one would be looking at all sorts of provisions, including unfair dismissal provisions, if he were wrong. But we respectfully submit he is wrong. The reference to employees and workers in subsection 1, and indeed in the passage from subsection 4 that I took the court to, is necessary because some rights in the Employment Rights Act, which fall to be construed by reference to this, mention workers, and some mention employees. Sometimes the reference to worker incorporates or encompasses employees as well, because all employees are workers, although all workers are not employees. So by way of an example, section 13, which was on the table that Ms. Monaghan handed up this morning, is a protection against unlawful deduction from wages. It is a protection afforded, on the words of the section, to workers. But of course that protection likewise encompasses employees. So it's necessary for this section to make it clear that references to employees and references to workers fall within Crown employment. But what it doesn't do, desirable as it might be thought to be from the perspective of the appellant, what it doesn't do is say that one can draw a distinction between somebody in Crown employment who is akin to an employee and somebody in Crown employment who is akin to a worker. There's nothing in the section which even attempts to do that. And that's not surprising, we would submit, because we're only considering section 191 if we don't have a contract. And one can't construe section 191 as drawing some sort of distinction between workers and employees, where the distinction between those two categories depends on the content of a contract which doesn't exist. Don't detect any doubt that section 191 was originally enacted to protect the position of people who had no contracts at all and are therefore dismissible at will, or would be were it not for the protection of statute. Almost the opposite position to a judge. So it's unsurprising, we would submit, that section 191 should afford all of the rights in subsection 2 to those found to be in Crown employment, in circumstances where a civil servant is in a position akin to that of an employee. Because, of course, our submission is that references to Crown employment essentially are there to protect the position of civil servants. Because historically it was, at the very least, unclear as to whether they served under contracts of employment or were dismissible at will. And I just take the court to one authority where the issue is considered. It's Betts 1940, bundle 3, tab 42. Decision of Mrs. Justice Simler, as she then was, sitting in the Employment Appeal Tribunal. It's just one short paragraph at 1946, paragraph 22. Because historically there was no certainty that Crown servants had contracts of employment, there could be no certainty that those in Crown employment or service would have employment protection rights in the absence of a specific provision applying the provisions of the Employment Rights Act 1996. Section 191 of the 1996 Act therefore extends certain employment rights to those who are employed under or for the purposes of a government department. I won't read it all out. So the identification of the raison d'etre of section 191 is to protect civil servants who are generally regarded, at least in the modern era, nowadays as employees. My lady, we included in our case reference to one or two extracts from Hansard to try to deal with this question. There's a disagreement between the parties as to whether we should be permitted to rely on them.
Well, we're very reluctant to look at Hansard for the purpose of construing, unless the SPAF home requirements are fulfilled. And I've just been glancing at the extracts as you were speaking, and they don't seem to me to comply with the SPAF home requirements. I'm willing to be persuaded otherwise.
My lady, I'm entirely confident in the submission that I make to the court that they comply with the first requirement, which is that there is some obscurity in the legislation.
Yes, it was the unequivocal promise by the minister responsible as to what that obscurity meant, is the second requirement.
There is no doubt that the minister says that civil servants are covered by the provision.
Well, of course they are. That's not difficult.
My lady, I accept that he doesn't go on to elaborate and say there's nobody else covered or anything along those lines. So, my lady has the extract for what it's worth, but I accept the
Well, it's of
concern.
interest
not
to
as
know
clear
that
as it
there's
might
nothing
be.
helpful in it.
At this stage of the morning, I'll take that, my lord.
At section 191, there are two groups, those who are in employment under a government department or an officer, and those who are under employment for the purposes of.
Yes.
What are each of those groups catching, do you say?
My lord, it isn't entirely clear whether those are two separate groups which the draftsman had intended to capture.
Well, I wonder about that because in the Northern Ireland draft, the under isn't there.
Yes.
So I just wondered, what was it intended to capture by under?
The ordinary connotation of under might relate to questions of subordination. I suppose that's an inevitable possibility.
I suppose what I'm trying to get at, does that tend to suggest that it is the equivalent of what one would expect in a contract of employment?
Firstly, yes.
And is employment for the purposes of a government department, is that something that one would expect to get in a contract of employment? Or is it rather wider?
It, of itself, it could be wider. Taken in isolation, all sorts of persons could be taken to be acting for the purposes of.
And is this not intended to reflect Section 230?
My lord, no. We would suggest it doesn't. We don't recognise a category of civil servant, if I can put it that way, who act other than in accordance with terms which would be akin to a contract of employment. The intention, we would suggest in this part of the section, must be to capture all of those working in the civil service. But to try and break down those working in the civil service into those who are on the one hand working under or on the other hand working for the purposes of isn't in many respects helpful, we would suggest. There isn't much that can be derived from that. There's separate provision made, for example, in the Act for House of Commons and House of Lords staff. That's sections 194 to 5. And those are individuals who are working for, putting that as neutrally as I can, the Crown, albeit they're working for the Crown in Parliament, as opposed to ministers or those acting pursuant to statutory functions. So it appears this part of the Act is seeking to capture all of those, broadly speaking, whose work for the Crown is, or might be thought to be, terminable at will, to ensure that they get the necessary protections. But there aren't, for example, the coverage doesn't extend to, as we understand it, statutory notice periods redundancy, which might be inconsistent with provisions for termination at will. So the aim, we say, of section 191 is to extend to Crown employees a raft of rights which we say can't properly be chopped up into one category or another. Perhaps another way to look at it is to say the draftsman hasn't, for example, said somebody who works under a minister shall be deemed to be treated in the same way as references to employee within these parts of the Employment Rights Act, somebody who works for the purposes of, and other parts of the Act. It isn't divided up in that way. And if that was what was intended, that's what one would expect to see in my submission, if this was akin to 233A and B. But it's not the way that it's drafted. When just to look at the position of judges then in that context, when Parliament has sought to include judges in the scope of protection of employment legislation, it's done so expressly and rather differently. So can I ask the court to look at the Equality Act, which we have behind tab 31. It's page 1414, please. Section 50 is the starting point for protection against discrimination for those in a public office. And we can see at section 50, subsection 2, a number of descriptions of public offices. Which includes at 2A, an office or post appointment to which is made by a member of the executive, and at D, an office or post appointment to which is made by the Lord Chief Justice or senior president of tribunals. And indeed at B, an appointment made on the recommendation of a member of the executive. So that's apt to capture, broadly speaking, judicial office holders. We then go over the page to subsection 3. We find the first prohibition. So a person who has the power to make an appointment to a public office within subsection 2 must not discriminate in various respects. Person who has the power to make an appointment, subsection 4, must not harass a person seeking or being considered for the appointment. 6, a person who is a relevant person in relation to a public office must not discriminate as to various matters which are set out there, one of which at D is by subjecting B to detriment. And relevant person is defined at section 52, page 1420. It's 52.6. Relevant person in relation to an office means the person who, in relation to a matter specified in the first column of the table, is specified in the second column. So, if the discrimination is in relation to a term of appointment, the respondent is the person who has the power to set the term, and so on and so forth. Any other detriment, it's the person who has the power in relation to the matter to which the conduct in question relates. And then harassment appears at the bottom, again, the person who has the power. Now that's a slightly convoluted provision, and it's necessary because of the unique position in particular of judges. Because otherwise, if one doesn't have provisions along these lines, it's much more difficult to identify who might be a respondent, who ought properly to be captured by the scope of protection. And that recognises, we respectfully submit, that judges are firstly not viewed by Parliament as workers. Secondly, that they are not viewed by Parliament as being captured by section 191. Because their circumstances require this rather more complicated and rather more specific set of protections. You heard submissions yesterday that the whistleblowing legislation has been carefully calibrated to provide appropriate protection. We would say something similar is applicable to these provisions. and I'll need to come back to them when I address you on the human rights points. But instead of protection being set out in this way, what one has under Section 191, is the extension of protection to the raft of rights in Section 1912. And if you're with me, that one can't draw the distinction that Mr. Stillett says you can draw, that includes unfair dismissal protection in circumstances where Parliament has provided elsewhere for security of tenure, and indeed wages protection where there is protection elsewhere for salary. And if we're right about that, of course, and as Monaghan's addressed you on this morning, they benefit from all the rights in the Trade Union and Labour Relations Consolidation Act. Of course, it's right to say that a minister can remove strike powers. That's not all that's in that act. Right to collective bargaining appears in the act. Now, leaving aside the question of whether judges, whether that's a good or a bad thing, of course I'd submit in the presence of this court that it's a good thing, but leaving that aside, there is already a statutory mechanism whereby the Lord Chief Justice represents the interests of judges. It is unlikely, we submit, that Parliament would have intended this sort of provision to apply to the judiciary. One of the
power for the Secretary of State to modify doesn't extend to this, does it, you're saying?
I think that's right, my Lord, yes.
Whereas the power to, if Parliament has given us the power to strike, then Ms Monaghan says the Secretary of State could take that away.
My Lord, yes. Well, Parliament gives the Secretary of State the power to do so, yes.
Which might be a bit odd in terms of judicial independence.
My Lord, yes. It's
it's all a bit fanciful, but
my Lord, I appreciate this. We are.
Your general point is that Parliament, one sees in the Equality Act how Parliament has dealt with the difficult issues which arise from legislating for judges, and it's not very satisfactory trying to sort of squeeze it into provisions which are really designed for something else.
My Lord, yes. It's the latest of additions to the appellant's case, having risen in this court for the first time. One of the reasons for that, we say, is that Section 191 straightforwardly is not apt to assist with the sort of difficulties which the court is asked to resolve. We've given one example in our case of why the appellant's interpretation would lead to difficulties which are difficult or impossible to resolve. And that's a claim for constructive unfair dismissal, which if the appellant were to bring such a claim against a putative employer, the Lord Chancellor, alleging serious failures in relation to welfare, training, guidance or deployment.
Well, of course, this depends upon your being right in your answer to Mr. Stillett's point.
Yes, it does. Yes,
So we just have to bear that in mind.
Yes, of course. Yes. If I'm wrong about it, we say, nevertheless, look at the Equality Act, look at the way in which Parliament does go about it.
Well, we've got that point.
But if I'm right about it, then what I'm simply seeking to do is to illustrate the sort of anomalies that flow. Now, the appellant in her case raised the Lord Justice Maurice Kay's dictum from the Court of Appeal, where he says it would be wholly inimical to the independence of the judiciary if any judicial office holder were to be discharging his functions under or for the purposes of a government department. The appellant says that that observation is bemusing because judges do serve on behalf of the Crown and are generally appointed by the Queen. And we have a couple of responses to that. Firstly, we say a judge is no one's employee for the reasons that we've already addressed you on. Leaving that to one side, we say a judge, in particular I'll stick with this appellant, does not discharge her functions for the purposes of the Lord Chancellor, because the Lord Chancellor's purposes don't include the administration of justice. That's what the 2005 Act does, to give the Lord Chancellor the role of ensuring the provision of administration and resources to allow judges to do their job. But judges don't perform their functions for those purposes. The functions identified by the appellant are Section 6 of the County Courts Act, that's the appointment power, and Section 100 of the Senior Courts Act, which is the deployment power. But district judges don't undertake work for the purpose of either of those functions. Not for the purpose of appointing judges or for the purposes of appointing judges to registries. Finally, in this regard, we say that the mere fact that the appellant puts it, its service on behalf of the Crown, well, that couldn't possibly be enough. If that were so, the House of Commons and House of Lords staff would already be included in Section 191. They wouldn't need Section 194. And we say that submission fails to recognise the distinction between the Crown as executive and the Crown in Parliament. And if the Court of Appeal held something different in Percival Price, that can't assist you in your task, we respectfully say, because it doesn't appear that it was ever argued. So you are approaching this, in essence, freshly, and we invite you to find Section 191 doesn't assist.
The Court of Appeal in Percival Price, as I understand it, had to find a conforming interpretation in any event, isn't that right? Or they were seeking to?
Yes, the part of the provision that they were troubled by was the part which excluded statutory office holders. What it appears that nobody argued, and we don't know whether they applied their minds to it or not. If they did, it was simply appears to have gone by agreement, was whether one got into the position of needing to look at the exemption for statutory office holders at all.
But
and one only got into that position if one was in the comparable provision to Section 1.
It looks as though when looking at this question of employment for the purposes of a government department, they took a fairly wide view of what that meant. In other words, that they said that was acting on behalf, service on behalf of the state. Is it possible to take a wide view of that, in that, as you say, the Lord Chancellor has an obligation to provide sufficient resources for the functioning of the courts? And could resources include the obligation to appoint judges so as to ensure that the work of the courts can be achieved, and that in doing so, the employment of judges for that purpose, or the appointment is for the purpose of his office?
I don't doubt that. The appointment of judges is a function of the Lord Chancellor, and that is for the purposes of his office.
Yeah.
The test in Section 191 requires us, though, not to look at that, but to look at whether what the judges do is for the purposes of the Lord Chancellor's office.
But does that not depend on how wide this elastic term for the purposes of an office is?
Inevitably, of course, it does. But what judges do is for the purposes of administering justice.
I understand that. What we're looking at is what the purpose of the Lord Chancellor is.
The purpose of the Lord Chancellor is fundamentally not to administer justice. The 2005 Act makes that clear, and part of the purpose of the Act is to ensure that the separation of powers isn't complicated by the position of the Lord Chancellor.
So does your argument suggest that the application of Section 191 to judicial office holders altered with the 2005 Act? Because obviously, until then, the Lord Chancellor was head of the judiciary. And in fact, appointed district judges.
Yes, but in that capacity was not a member of the executive. The constitutional difficulty we have before 2005 is the very unusual position of the Lord Chancellor.
This is true. I was simply asking whether your submission is that the application of Section 191 changed with the 2005 Act.
My lady, the answer to that is no, because the Lord Chancellor before 2005 was treated as, in effect, three separate aspects of the work of the Crown.
Well, possibly two separate aspects of the work of the Crown and one completely independent of the Crown, i.e. Speaker of the House of Lords.
Yes, in fact, my lady's right, yes.
That might be correct,
Yes,
mightn't it?
I suspect that is right.
Yes, and you've got some authority for that proposition?
The proposition that
The role of the Lord Chancellor as head of the judiciary and the role of the Lord Chancellor as head of his department,
yes,
which it was, were two separate things?
well, lady, if I need to produce a case, I'll need to have a look at that over lunch. But
Well, if you can find anything, it'd be interesting.
Well, the way we put it, my lady, is this, that prior to the 2005 Act, it was always the case that the Lord Chancellor performed, from a constitutional perspective, different roles applying to different branches of the Constitution. And so the Chancellor acting as head of the judiciary was not acting in the same branch of the Constitution. Chancellor heading a government department. That's the distinction which I was seeking to draw. I don't know if my lady had something else in mind.
Well, I'm just trying to make sense of Section 191, subsection 3, as it might have operated before the 2005 Act. I mean, I'm not expressing any view one way or the other, but yes. I take your point on the effect of the 2005 Act, but the fact remains that the Lord Chancellor, before that, basically was head of the judiciary in the sense of being top judge, but he was also head of the judiciary as being the person who was responsible for the justice system.
Yes, can I reflect on that? And if I've got anything further to say about it, come back.
You may not have. I mean, I appreciate that this is all very high-level stuff, isn't it? Yeah.
It is. On any analysis, the constitutional background to this is very high-level stuff.
But it is one of the reasons why so many powers, as in Schedule 4 to the Constitutional Reform Act of 2005, were thereafter vested either in the Lord Chief Justice on his own, or his concurrence was required.
Yes,
yeah.
Precisely. That
was because of the Concordat that was
yes, but it could be the report of the House of Lords Committee on the Constitution, which looked at the bill. May throw some light on this.
Yes.
Need little time.
But there is no doubt that one of the aspects of the bill which takes up quite a lot of its content, if I can put it that way, is moving powers away from the Lord Chancellor to ensure that various branches of the Constitution are kept separate on the face of the statute and not merely through the skill and judgment of the person who happened to sit on the woolsack. My My ladies and my lord, that was what I wanted to say about section 191. That leads me to Article 10. And there is, as we understand it, really one issue between the parties in relation to Article 10, and that is whether the appellant's undoubted Article 10 rights are properly protected in the absence of access to the parts of the Employment Rights Act which deal with whistleblowers. And we say, of course, that they are. So firstly, there can be no question of loss of office as a result of making a disclosure in light of security of tenure, and because any attempt to remove from office would have to be carried out in accordance with the statutory procedures. And of course, the cases to which you've been referred, that's Bates and Heinisch and Kudish-Kina, are all about removal from employment or partnership or whatever it may be. And nor, we say, can there be detriment by way of salary reduction, at least not without a remedy. And Mrs. Justice Simler, as she then was, sitting as the president of the EAT, we say was right to note, don't ask you to look at it, but it's paragraph 39, page 245, that any alleged failure to act in accordance with statutory requirements is subject to the oversight of the court. And that was accepted below as we understood it, and as the Court of Appeal noted, paragraph 83, page 208. But the appellant contends before this court that the protection from loss of office and salary does not of itself provide a remedy, and that submission, we say, is wrong. And I deal with that partly by reference to my Lord Carnwath's questions about how one approaches enforcing rights. An attempt to remove from office could be challenged by way of judicial review and would be successful if the decision to remove amounted to a violation of Article 10, or indeed otherwise failed to record with the statutory limits on the power to remove, which would have to be read in accordance with Article 10. The remedy would be for the decision to be quashed. Interim relief would be available. We have an example of it happening not in relation to a judge, but in relation to a different kind of statutory office holder in the case of Shoesmith, where the Court of Appeal held that judicial review was available in those circumstances. And a failure to pay salary could be challenged, as I noted, either by way of JR, of the decision not to pay, or an action for breach of statutory duty, the remedy being either a mandatory order requiring payment or damages. What the Court of Appeal went on to consider was whether a claim under Section 7 of the Human Rights Act as an alternative would represent adequate protection against other forms of whistleblower detriment, that is, detriment short of dismissal or loss of salary. Can I ask the court to look at the way that the Court of Appeal dealt with it, because we say their reasoning is correct. It's page 208. It's in the core volume.
Paragraph?
It starts at page 83. Can I ask the court just to, it's about a page to read, 83 to 88, please.
Paragraph? Sorry,
I think it's paragraph 83. Yeah.
Paragraph 83 on page 208 to paragraph 88 on page 209.
I think you can carry on.
I am grateful. We respectfully adopt that reasoning, and I propose to add briefly to it as follows. The appellant complains about essentially two matters. Firstly, the possibility of obtaining better compensation in an employment tribunal, and secondly, the fact that the employment tribunal is a no-costs regime. And we say neither of those complaints can survive the correct finding of the Court of Appeal that there is no entitlement for the remedy to take a particular form, or more specifically for it to be in the same form as is available to other persons or classes of person. The difference in regime, we say, we understand it can properly form the basis of an Article 14 claim, but it can't assist in relation to the Article 10 claim. The Human Rights Act empowers the court to grant any relief or remedy as it considers just and appropriate. Where damages are concerned, it must take into account the principles applied by the European Court under Article 41. And in those circumstances, the appellant can't show that her Article 10 rights would not be protected by the court. It's a necessary function of the court's role in considering a Section 7 claim that it gives effect to her Article 10 rights. But without prejudice to that submission, we say there's nothing in any event in the complaints about either the adequacy of damages or the costs regime. And I will deal with it because it will be relevant to Article 14 as well. So far as damages are concerned, if the court is required to take into account the principles applied by the Strasbourg Court under Article 41, we say there can't be a proper complaint. But of course, in any event, there's no limit on the damages to be awarded. The court is empowered to grant such relief as it considers just and appropriate, which means the court can, if it considers it just and appropriate, make awards in relation to injury to feelings, aggravated and exemplary damages. In the passage the court has just read, the Court of Appeal cited with apparent approval the judgment of Mr. Justice Leggett, as he then was, in Al Serran. Which was a case in which he concluded it's appropriate to assess damages by reference to the amount of compensation that would be awarded in accordance with the applicable principles of English law. Quite a lengthy section, so I don't propose to go through all of it now, but can I give the court the reference? The case starts at page 1611, tab 39 in bundle 3. It's a very long judgment indeed. The relevant passages for our purposes start at 1786 in a section headed Relevance of Domestic Standards, paragraph 930. A section down to 932, which is then picked up again in a section starting on page 1788, headed Approach to the Quantification of Damages, which is dealt with paragraphs 937 to 943. 942, in fact. I don't propose to take the court's time by asking you to read those relatively lengthy passages now. The short point is that His Lordship reaches the conclusion that it is appropriate to assess damages by reference to compensation which would be awarded in accordance with applicable principles of English law, which means it's plainly open to a claimant who asserts that she has suffered detriment by reason of having made a protected disclosure and who brings a claim under Section 7 to argue that the judge should assess damages on the same basis as an ET and applying the same principles. As for the no-costs regime in the employment tribunal...
Well, obviously we're going to form our own view as to whether Mr. Justice Leggett was correct
Yes.
about that in that particular context. But he was comparing the level of damages for breaches which amount to torts in domestic law.
Yes.
Straightforward torts, basically. One of the problems that there has historically been about the employment legislation and the equality legislation is that although they create either statutory breaches of contract or statutory torts, whichever way you look at it,
Yes.
it took a long, long time before people could work out that actually there was an entitlement to substantial damages for injury to feelings.
Yes.
Because that's a bit of an exception to the general approach of domestic law. So I'm wondering how much assistance we're going to get from Elsa. I mean, your basic point is that the Convention doesn't prescribe any particular remedy for breaches of that, and there could be a choice, and there could be a choice between Section 7 and the claim under the Employment Relations Act. And
it is. So this submission
so
is...
to try and persuade us that the Section 7 is as good as is, I doubt if we're going to be deciding that.
You don't need to decide it for the purpose of the Article 10 claim, if you're with me on it. No. But once we get to Article 14, then you may want to look at it, my lady, because one of the matters which no doubt the court will weigh in the balance is whether and to what extent the difference in treatment which is complained of impacts negatively upon the appellant. So to that extent, the submissions I'm making now are slightly out of order. And can I say this about Alceran? I accept it doesn't give a conclusive answer as to the damages which would necessarily be available in a Section 7 claim. Firstly, because it's a first instance decision, and you will form your own view about whether it's right or not. And secondly, because what is just and appropriate in an individual case will depend upon the circumstances of the particular case. But at the very least, we say it's open to a claimant to argue that the same approach to compensation is appropriate in a Section 7 claim as in the Employment Tribunal. I was turning then to the question of the no costs regime in the Employment Tribunal, and of course not being required to pay costs and not being able to recover costs bring pros and cons. A claimant with a good claim may be disadvantaged in bringing a claim in the Employment Tribunal if she is unable to recover her costs. It is not at all unheard of for claimants in the Employment Tribunal to obtain substantial awards which are all but eliminated by costs. It all depends on the circumstances, and we would suggest it can't properly be said that a no-costs regime is always and inevitably better for all claimants and in all circumstances. And finally, on Article 10, can I deal with the assertion that there is no effective internal grievance process available to judges, or at least no grievance process which can deal with a whistleblowing complaint? Because we say that submission is wrong. You were taken to Lord Justice Tomlinson's decision on the grievance. And I'll ask the court to turn it up. Starts at 585, which is towards the back of the core volume. And you were taken, I think, to paragraph 4 on page 586 and in particular to a passage in which his lordship said, I also considered and still consider that the grievance procedure is completely unsuitable for the resolution of a grievance of the nature instituted by Judge Gilham. And if by that he meant I can't consider whistleblowing complaints, then that might be a matter that this court would want to take into account. But his concerns are different in our respectful submission. Can we ask you to look within this paragraph at a section on page 587, 3 lines down, in which his lordship says that the issues raised by Judge Gilham's grievance are so wide-ranging and diverse that they do not admit of resolution within the confines of a procedure such as this. Judge Gilham's grievance amounts to an attack upon the entire management style and organisational culture which permeates the administration of family justice in what is now the family court, particularly insofar as it relates to the organisation of the work of district judges. In reality, it is a wider attack upon the administration of the entire civil justice system and of the judicial culture which underpins it. This is far too wide a canvas to lend itself to this treatment. But that's not the sort of thing that an employment tribunal could deal with either in our submission. Lord Justice Tomlinson is not saying that the grievance procedure is inapt to deal with this grievance because he can't deal with whistleblowing complaints. He says that the nature of the grievance is, amongst other things, so broad that it's difficult to see how it can be properly dealt with. But, paragraph 5, nonetheless, I was advised by HMCTS that it was desired that the grievance procedure should proceed to a conclusion, and we see over the course of a lengthy decision that he does deal with the grievance. His reasons are set out at length, starting on page 590, with an overview at paragraph 12, and considering complaints of overwork, page 421, a lengthy section running through to 431, where he deals with the email protocol, 432, judicial safety, 435, a specific incident in 2013, 439, a meeting in June 2013, and then a conclusion on page 615. As part of that conclusion, you were taken to the passage where his lordship says, I would, however, add my voice to that of those better informed than me who've expressed concern over the safety of district judges when conducting. I won't read all of that out. You were taken to it yesterday. That's a concern about safety. A couple of things to say about it. First of all, Lord Justice Tomlinson doesn't make recommendations about safety, but nor could an employment tribunal. That aspect of the grievance is not about detriment for having blown the whistle. It's about the underlying complaint. It would not be to the employment tribunal that the appellant would be expected to go to resolve, to have recommendations made about safety, whether those are matters within the judiciary or the Ministry of Justice or an external body like the Health and Safety Executive, would be a matter for her. But it doesn't inform the scope of an internal grievance process about whistleblowing detriment. Simply ask the court that if you are at all minded to accept the appellant's submissions that there's no internal process to protect a judge's position, we'd ask you to read that decision in full. My ladies, my lords, that's all I wanted to say on Article 10. I'm due next to move on to Article 14. It's only 5 to 1. I'm in the court's hands as to whether you want me to do 5 minutes or start at 2 o'clock.
I think we're entirely happy to do whatever you would like to do, Mr. Collins.
It might make sense for me to start with Article 14 after the short adjournment, my lady.
Very well. We will look forward to hearing from you further at 2 o'clock.